challenging the legality of a new Chapter 56 in Title I of the Texas Administrative Code relating to new reporting requirements for district and county attorneys in only 13 of Texas's 254 counties. Other plaintiffs include the Travis County District Attorney, myself, the County Attorney of Travis County, the El Paso County Attorney, and the El Paso District Attorney. These new Attorney General rules exceed the Attorney General's authority for rulemaking and invade privacy rights of third parties without statutory justification, while at the same time requiring prosecutors to disclose information they are statutorily required to keep confidential. Specifically, the challenge rules require only certain Texas prosecutors to disclose entire case files, explicitly including confidential work product and privileged communications, as well as private personal information about law enforcement officers, crime victims, arrestees, criminal defendants, and witnesses. It includes also protected information such as grand jury testimony, medical, mental health, and substance abuse and treatments. These are not the only materials that the Attorney General would require elected prosecutors to disclose, but are examples to demonstrate the extraordinary scope of this new rule. Beyond the required contents of the initial quarterly and annual reports required under this new Chapter 56, the chapter also creates the Oversight Advisory Committee, consisting of Attorney General appointed employees of that office, that they may request case files based on submitted reports or any other information that the committee desires. District and county attorneys have long served as the primary gatekeepers of this sensitive information, as they are chosen by, operate within, and are accountable to the very communities which they each serve. These new Attorney General rules would further require the electronic transmission of these records to the Attorney General's office, even though some laws specifically prohibit such disclosure electronically. These rules further attempt to authorize the Attorney General to initiate proceedings to remove elected prosecutors from office for failure to disclose this information, which is beyond his authority under existing statutes. In short, the rules invade the separation of powers of the executive, legislative, and judicial branches of the Texas government and violate citizens' rights to privacy protected by multiple state and federal statutes, and they cannot go unchallenged. This lawsuit is about protecting confidential information of our most vulnerable population and an unconstitutional overreach. It's about keeping our promise to the residents of our jurisdictions and respecting the rule of law. And next, El Paso County Attorney Cristina Sanchez will say a few words.
Thank you. Good afternoon, and thank you, of course, to our Travis County Attorney, Delia Garza, members of her team, and of course, I'd like to acknowledge my colleague, Assistant El Paso County Attorney Bernardo Cruz, who's joining me here today. Myself, along with the 34th District Attorney, James Montoya, and El Paso County are here to file and support a lawsuit with regards to these rules that have been promulgated by the Office of the Texas Attorney General. Local prosecutors have the mission of making sure that justice is done. A fundamental piece of that mission is ensuring that the Texas Constitution and state laws are followed by everyone in the state. These new rules created by the Office of the Attorney General conflict with that mission, violate the Texas Constitution and Texas laws, and place an extreme burden on my office and the offices of other local prosecutors across the state. Every minute that local prosecutors take to try and comply with these vague rules takes away valuable staff time and resources from where they are supposed to be. And that's serving our victims, that is responding to law enforcement questions, that's working with our law enforcement partners, and ensuring that justice is done in each of our individual communities. Every legislative session, local communities, and in some instances, specific communities across the state, bear the burden of doing more with little to no support from what is being requested. These rules can now be added to the list of additional costs to communities to effectuate what we know as unfunded mandates to localities. As I mentioned earlier, these proposed reporting requirements raise significant concerns regarding the financial burdens that they would impose in each of our communities. These rules will entail substantial expenses across various aspects of county administrations, including hiring additional personnel, ensuring and requiring that there have to be certain technological upgrades, ongoing maintenance, and administrative tasks. These are in addition to those tasks and those operations that we already currently have and that we are already currently complying with. The sheer scale of this workload, spanning from manual review of case files to transcriptions of case transcripts, will require significant resource allocations and significant operational costs. The potential for long-term financial implications and sustained compliance for El Paso County and counties across the state who are affected by this rule underscores the concern that our offices have and the need for us to respond to these rules. We stand ready to fight this particular rule. We stand ready to respond. We believe there's a need and a just cause for each of our local communities to respond to each of these rules that are being imposed and being burdensome to each of our counties. Thank you.
Hello, good afternoon. My name is Stephanie Richardson. I am the Victim Services Director at the Travis County Attorney's Office. I have been in this field for over 20 years as an advocate for victims and survivors. I started out straight out of high school, going to Austin's very own Center for Battered Women's, working as an intern, and I've worked with victims and survivors in roles such as advocate, director, sexual assault advocate, and also as a program administrator. I'm also a licensed professional counselor. As this rule will impact the safety of victims. With crime, with cases, there are victims, and our department works with victims to ensure their rights. The Texas Crime Victims' Rights has written in the Texas Constitution, Article 1.30, that a crime victim has the right to be treated with fairness and with respect for the victim's dignity and privacy throughout the criminal justice process, and the right to be reasonably protected from the accused throughout the justice process. The Texas Crime Victims' Right, as stated in the Victim Services Division of the Texas Department of Criminal Justice, states, victims have the right to be reasonably protected from harm or threats from the accused and privacy as far as reasonably practical, and the contact information of the victim may not be part of the court file. Victims, because they are part of the case, they are part of the case file. All of these rights are guaranteed by the Texas Constitution and by the Texas Code of Criminal Procedure. As advocates, we are tasked with ensuring these rights for our victims. Making all information available to the AG office will bring into question the role of advocates and how we can ensure the safety of victims if their information is disseminated with no regard to safety. We will also have no control over who gets that information and where it goes. This will impact our relationships and our rapport building with victims as it jeopardizes their safety. This will also impact their participation in the criminal justice process. We are obligated to ensure the safety of our victims. It is our priority, and this new rule will impact that. Thank you.
Those are our prepared comments, so we could take a few questions.
I'll open up for questions. Jamal, CBS. Angela.
The Attorney General's office has said these rules are designed to bring in rogue DAs and make sure criminals are prosecuted. What is your response to that?
Ken Paxton was not elected to be the prosecutor of Travis County. Delia Garza was elected to prosecute misdemeanor crimes, and Jose Garza was elected to prosecute felonies, and I'm sure the El Paso County Attorney feels the same. And so it's severe overreach, and I appreciate the question because this purely does seem like a political issue rather than anything else. We are required to report already, we are required to respond to open records requests. We are required to give all types of information. And so, this is about being able for the voters to have a voice, and they didn't elect Ken Paxton to make those decisions. In fact, the Constitution does not allow him to be a prosecutor. He is not a prosecutor. And so I think, along with the many other counties that are affected by this rule, are very concerned about this extreme overreach.
Kelsey, Katie.
Yes, so Travis County DA's office has, faced scrutiny when it comes to prosecuting certain crimes and, spotlight over that. And supporters of this, when it was first proposed last year by Ken Paxton, have said that this will, gain accountability when it comes to it. I mean, what is your response to that?
I mean, it's a similar response to the previous question. The people that hold local elected officials accountable are the voters. And many times, if local voters do not agree with the performance of one of their electeds, they have and they will, choose somebody else. And so there's already a pathway in place that holds elected officials accountable. And it doesn't call for additional oversight that we believe in the petition explains is unconstitutional. Do you want to answer any of these?
Sure. Going back to, of course, the rogue comments, and then, of course, in terms of accountability for local officials. I mean, in the bigger context, in terms of accountability, let's talk a little bit then about state accountability as well. Let's talk about the reasons in which they are asking for some of this information. And I think we hit the nail on the head here, where it appears to be a political maneuvering on certain counties. Like, make no mistake that this rule only applies to certain counties. It is not every jurisdiction, it is not every county within the state of Texas that is forced to comply with this rules. And so the concern that we have here is, yes, we're concerned about the state overreach by the Texas Attorney General for each of those localities that are affected. We are concerned, though, also about the financial implications that those counties will have to bear. Again, certain counties that will have to bear. It was a dismissive comment that had been made in terms of our comments and reactions in response to the proposed rules, where we had the ability to provide that feedback and comment, that were disregarded in terms of that's not going to be an issue for each of your localities. Either that's a gross misunderstanding of how local governments and their budgets work, or it is a extreme oversight and dismissive position and stance that the state of Texas is taking. If this has been a concern, and if this in fact was going to be an issue, where is the budgetary allocation for that? I can imagine that each of the jurisdictions throughout this state, to include all of those that are affected by this rule, are going through and will go through a difficult budget session for a lot of reasons, right? And so how are we going to respond to that? What is the state doing to assist and to help us? So the only other thing left to think through is that this is definitely not only an overreach and an unconstitutional overreach, but that is definitely a purposeful overreach for certain localities in the state of Texas.
Yeah, along those lines, this dilemma of political maneuvering and whatnot, overreach, does this maybe then extend to the territory of encroaching upon the voices of the voters who live in your areas? And if so, how do you view that? How dangerous do you view that action of overreach?
That's absolutely what it is. It is dangerous, and it should be concerning to every Texan. There are 3 branches still in this state, and there's 3 branches of government still in this country. And we believe we've been put in this position that we have to challenge this, to follow the rule of law, to make sure those functions are put into place to protect people, to make sure that one branch does not have too much power, because that can be dangerous. I mean, we're seeing that at the national level. And so this is something that we feel that we have to do to make sure that we are protecting the rule of law and protecting the authority that we have been given. We are the local prosecutors. And again, if the people that hold us accountable are the local voters, and they should be very concerned about this overreach, this power grab.
Follow-up, Katie.
Yes, so I know you mentioned certain counties, because it is a population of, I think, 200.
400,000.
So I just want to know, why do you think that is? Do you think you guys are being targeted, or I mean, what is your reason for believing that? Because I know the emphasis is on certain counties in Texas.
Well, I think almost all of those 400 counties are Democratic-leaning counties. And I know there has been statements made in the past about concerns about, the performance of, as your first question, spoke to. And so it is very targeted. It started, when this rule was first proposed, the population threshold was smaller, so it included more counties. And then when it was re-proposed, they had ratcheted up the population to only impose this on 13 counties. So clearly political, and we have to fight back and challenge it.
For all of those same reasons, again, right? You're left only to believe that those are very targeted attacks. But again, the focus should also be on the financial burden that these rules are going to put on these certain counties. Again, there was definitely a change in terms of the population when it was first proposed to now, and even the timing of the proposal, which is during a legislative session as well, which is concerning as well. But we have to respond. There's a time frame here in which the first reports will be due, which is pretty soon, at the end of June, July as well. And so the need for action and the timing for action was now.
All right, folks, thank you all. If you all have any follow-up questions, please let us know. Myself or Deanna can help you all out. Thank you all.
Thank you. Y'all. Thank you. Thank you.
Check. So you can use this.
Doing it right? Yeah. Yep.
Oh. Yeah, we can do it right here.
No, we can do it. Yeah.
Hi, Jamal. Nice to meet you.
Nice to meet you.
You had a chance to review the post.
Yes.
Can we take a couple steps back? I think the light's a little bit better. Yeah, right there.
Okay.
I don't have to move. Give me a second. Do you mind, David? Yeah. Oh, yeah. Thank you.
Thank you.
I'm rolling.
Awesome.
You know that they refer to the DA, not the CA.
The CA, yes.
So,
Okay. Yeah.
They're talking about the district attorney.
Yeah.
I know it's confusing because we're both Garzas.
I know. Well, I thought he was going to be here, but I just figured it's
Yeah.
county district.
Yeah.
But having a chance to have reviewed those comments from the TMPA, what are your thoughts on how, I guess, certain law enforcement groups view the way that things are done here in the county or on the district level?
Sure. Well, first, I want to say this incident was incredibly tragic, and our office sends the condolences to the victim and the victim's family. Law enforcement are great partners. We need them in the work that we do. They are they're necessary in the work that we do. And so it's unfortunate when we have these criticisms back and forth, frankly. But law enforcement are police officers. They're not lawyers. And they don't understand the legal challenges that each of our office faces, especially when it comes to individuals who may be suffering from mental illness. It is part of the public record that this individual was held incompetent, and when someone's held incompetent, a prosecutor can't prosecute them. It is unconstitutional. And so I understand frustration, but not when frustration is based on incorrect information. They don't understand the legal hurdles faced in these instances and the significant lack of mental health services that our community has, and that is largely the responsibility of the state. And when we don't have the appropriate mental health services, it's incredibly hard to provide those services to people in our community.
Yeah, thank you. I appreciate your time.
Okay.
Yep,
Are
thank you.
you able to do anything in Spanish by chance?
I can't. I mean, I wouldn't feel comfortable.
Okay.
It would
No,
be bad.
they
It would
asked
be
me to
bad.
ask you.
Okay, thank you.
Thank you. I appreciate it. Thank you. Hey, Rob, look how fancy this is. Fancy, fancy.
Yeah.